Day 7 of Derek Chauvin's trial was well underway today, but we didn't see much progress because they're trying to seat the jury panel, and nobody was added today. We've seen sort of a slow pace, sometimes fast, sometimes slow. We've had 2 get selected, down to 1, a couple of 1 days, but today 0. No additional jurors seated after today's hearings. But we did have some activity taking place early on in the morning where they're still hashing out a lot of issues. Remember, we've spoken about this. At the beginning of every day thus far, they've been fleshing out what are called motions in limine, which are the rules for the trial. All of that still has to be established. Yes, there are rules of evidence. Yes, there are rules of criminal procedure, but those are sort of general rules that you have to follow in the trial. Specific to this trial, specific about these witnesses, these expert witnesses, the type of things that people can say during their testimony in the court of law, all of that is subject to modification of rules, and those are being established right now. They're called motions in limine. And yesterday we were talking about this fact that the Minnesota City Council, Minneapolis City Council, settled with the George Floyd family for $27 million right in the middle of the jury selection. And so people are asking, well, how is that fair? Especially if they come out and they say it's the biggest award that they've ever granted for a case like this, something that was national news. They use a lot of language like this was a unanimous decision. If you disagree with that, then maybe you are going against the unanimity of the city council. And so maybe people are thinking that if they're on the jury panel, they might be biased to side one way or the other. So this is a big issue, and it hasn't been settled yet. Today, early this morning, they were hashing this issue out in court. This article comes over from the Star Tribune. I've mentioned they're doing great reporting over there. The judge presiding over the murder trial of Derek Chauvin said on Tuesday he is weighing a couple options. Number one, whether to delay the trial or move the trial in the wake of the city of Minneapolis settling $27 million lawsuit. Payout being made to settle the federal lawsuit brought against the city was announced last week as jurors were being questioned about whether they could be impartial in the trial. Hennepin County District Court Judge Peter Cahill said just before the midday break that he's considering a delay of the trial or having the proceedings moved to another city in the state. He added that he alone will question the 7 jurors on Wednesday, so that's going to be tomorrow, who were seated when the settlement was disclosed at a news conference. He wants to size up whether their ability to be fair to Chauvin has been compromised. And I'm very curious about this line of questioning. Basically, the main question I will have initially is, have any of these jurors even heard of the settlement agreement? Because they're supposed to be sort of not fully sequestered. They're not being set up at a hotel and told to be isolated from everybody and everything, but they are not supposed to go out looking for these stories. And I just kind of want to see how ubiquitous this story has been for them. Are they seeing it on Facebook? Did somebody tell them about it? In other words, what is their media interface looking like right now because they're not sequestered? And if they heard of the settlement, well, that might show you that you kind of have a leaky bucket. You have a bunch of jurors who are not supposed to be obtaining any information about this case, getting information about the case, which might lead to the judge saying, well, we've got no choice but to sequester these people. And that means that they literally get cut off from the rest of the world. It's kind of a tall ask. I don't think anybody wants to go that route. I think the last time, I think we've seen it a number of different times recently, but the big one that I remember, I think, is during the O.J. Simpson case, when I think that they were sequestered for a very long time, and that was a big deal. And so we kind of want to avoid that here, but may not be able to, maybe out of options. If the jurors are supposed to not be getting the news and they're getting the news anyways, what other choice do you have? So that line of questioning is going to take place tomorrow. Cahill said he does not intend to sequester the jury any sooner than when deliberations begin and will not award the defense additional peremptory strikes that can be used to excuse jury candidates. And the reason he said that, so no additional peremptory strikes. So a refresher on that, peremptory strikes are, you can just get rid of a juror without any cause. Typically, you don't want to use those. You want to have the court strike the juror. The judge listens to the same testimony that you, Mr. Defense Attorney, listen to. You want to strike that juror, but you don't want to use your strike because you only have so many strikes. So you ask the judge to strike that person for cause, and you find something in their testimony that shows that they're unbiased, and the court goes ahead and does that. Here, what Eric Nelson was saying is, in order to remedy the improper influence of the settlement agreement, one of his suggestions was that the defense get more strikes so that they can clean up some of the mess left by the settlement. And if people have heard about the case, then he can just strike them. The judge isn't even going to have to consider to strike them for cause because they're going to give him additional peremptory strikes. Well, the judge just kind of looked at that and said, that's a nice request, but if these people are biased, if they're already not able to be impartial, then I'm just going to go ahead and strike them for cause. I'm not going to require you to use an additional peremptory strike. The court's just going to do it on its own motion, on its own volition. So he's saying that he's not going to give them any additional peremptory strikes, probably because he just doesn't think they need them. He knows that this has been a new development and he'll do the striking. He doesn't need to give the defense any additional peremptories. He reinforced that decision Tuesday afternoon when the defense sought but failed to reclaim from the judge one of its peremptory strikes it felt forced to use in the morning when one jury candidate said he heard about the settlement but pledged impartiality toward Chauvin. Before jury selection resumed on Tuesday and ended with no prospective jurors joining those already chosen this past week, the judge expressed exasperation that the city's announcement of the payout came during Chauvin's live-streamed trial. Defense attorney Eric Nelson pointed out that a Washington Post article last week, an unidentified city official said that Chief District Judge Todrick Barnett greenlighted the settlement's announcement. Chief District Judge Todrick Barnett greenlighted the city's announcement, the settlement announcement? So a judge from the courts, who's the chief district judge, which might be higher up than the current district judge, Peter Cahill, somebody in the court system, green-lit that in the middle of jury selection? What? That could be problematic. But Judge Cahill says, well, he spoke with Barnett and said what the Post reported, quote, is not an accurate statement. So are you serious right now? The Washington Post posted something that is not accurate? That's ridiculous. Well, so we have a clip of this because it gets a little bit tense, a little bit, not too much, of Eric Nelson bringing this back up to the judge's attention. And you're going to hear him talk about this. He says, I should have brought this up yesterday when we were kind of talking about the settlement agreement stuff, but I didn't. But we did mention this when we were in chambers. And so what chambers means is you're sort of off the record. You go back into the judge's room, into their office, or they have a special room, depending on the court and where you're at. Typically, though, it's the judge's office. So both the prosecutor will go back there, the defense will go back there. Any interested parties will go back. It's not being recorded. It's off the record, and you can actually hash out issues there. And sometimes you can have very good progress in a more informal conference, in an informal meeting place like that. But it's not on the record. And so what Eric Nelson has to do is come back out in court and say, I'm going to make a record about this issue. And he does. And so the judge is kind of up to speed on it. So if you kind of watch the two of them communicating and understanding each other, and you as the audience, you're going, well, I kind of miss what they're talking about. It's because of that. They've already spoken about this issue and now they're rehashing it again. And so hopefully I've laid enough foundation that this makes sense. But this is the conversation taking place specifically about whether a judge in Minnesota greenlit the settlement the settlement agreement, the settlement amount for the $27 million, and specifically said, yeah, go ahead and just release that right now. Release it right in the middle of voir dire of the Derek Chauvin case, which of course is the defendant alleged to have killed George Floyd. That's a big deal if that is true. And so Eric Nelson is bringing that up to the judge's attention, because if that does come out later to be true, if this does result in Derek Chauvin being acquitted, and we later learn that there was some sort of interface between the judiciary, which is the judges and the courts, and the city council, which would be the legislative branch, if there's some sort of collusion there and they're communicating about that, this might be improper, right? It's the court now being lumped in to the perception of bias that the city council, I think, unequivocally clearly laid out when they agreed to that settlement at this particular time. So let's take a look at Eric Nelson. Here he is this morning.
Yesterday, during the course of our hearings and proceedings yesterday, for purposes of the record, relevant to the request for continuance, I neglected to reference the article I did in chambers later, but there was an article in the Washington Post that was published on March 12th of 2021, wherein the Washington Post reports that a Minneapolis official said the city had been concerned that this announcement could affect the trial. The official, who was not authorized to speak.
What was it?
Pardon?
What was it? Okay, go ahead.
Sorry. So I'll just restart, Your Honor. A Minneapolis official said the city was concerned that the announcement could affect the trial. The official, who was not authorized to speak publicly, said the city consulted with Hennepin County Chief District Judge Todrick Barnett, who told the city it could proceed. Barnett did not immediately respond to a request for comment. I think it's just simply for purposes of establishing the record relevant to the motions yesterday regarding the release of that information.
And I don't know if Judge Barnett is clarifying
I don't
that
know
is not an accurate statement. I'm going to leave that to him and
yes.
dealing with the media. But
But in terms of any of the requests for relief yesterday, I do think it's a question of who made this decision to announce this. So.
And I think the bottom line is this is a federal lawsuit. This court was not involved. And as I recall in my discussions with Judge Barnett, the answer was, we can't tell you what to do. And I think he expressed the concern that we would have about doing such a thing in the middle of jury selection. So there was no approval by this court. We had no authority to approve any release at this time.
I just simply am making the record.
I think the city is trying to try and dump their responsibility back in the court where it does not belong. Nevertheless, it is what it is. We'll deal with it tomorrow.
Thank you.
All right, let's go with our first juror.
All right, so you heard him, not particularly happy about it. So city council, they're dumping their garbage back over here. I'm not calling the settlement garbage, but they're making it our responsibility. They're trying to settle their stuff. They know we're in the middle of this trial. They know we're right in the middle of jury selection, and they did it anyways. So Eric Nelson's making a record, says, hey, just there's a news article about this. Washington Post said one of our judges here in Minnesota greenlit that approval. Judge Peter Cahill turns around and says, well, I don't think that's an accurate statement, but it's for him to clarify that. I'm going to let him come out and address that. He can deal with the media, but we didn't approve it. This court didn't approve it. We didn't have any influence in it. And Eric Nelson just says, "Yeah, I know. Just making a record, Judge, because this is going to be a problem down the line," which it very well could be. We don't know how this is going to shake out yet, but they're making a record. They're putting a stake in the ground. This doesn't feel good when you have a judge interfacing with the legislative body, the city council, to green light a $27 million settlement before a jury is even seated in the middle of the jury selection. Okay, it would have been totally different if it was before or after the trial, but it's right in the middle of it. And it feels like it's intentional. So Eric Nelson is bringing it up, and we'll see what the judge does with it. So next up, then, we sort of get through that issue. We are now going to transition a little bit. I've got two long clips. I know they're long, but they're good. There's some good stuff in here that I think is very important. If you are a juror on this case, do not watch this, all right? If you're a juror on the George Floyd case, do not watch this. It's not for you. This is for other people who are interested in what's happening pre-trial, because the trial has yet to start. The jury selection has started, but we have not had opening arguments. And so this is all surrounding a motion in limine, which is establishing the rules for whether or not they can talk about George Floyd's 2019 prior. And so the first clip is going to be the judge who's laying out some background on this. And so before the arguments start, I'm going to show you the judge, then I'm going to show you the defense attorney's argument, a little bit of it. It's a long argument, so he basically goes through four elements. We're only going to take a look at the first element. Then I'm going to read you what the prosecution response is, and then the judge is going to address this tomorrow. So I kind of just ran out of time for all the different clips, so I'm just showing you what I think are the most pertinent clips here. The judge giving some factual background, and then the defense attorney making the argument. It's their motion. Why do they want to get this stuff in? Why do they want to talk about George Floyd in 2019? And there were two cases, right? Obviously, the one in 2020, May 25th, I believe was the date. And that was the one that we all know. But in May 5th of 2019, there was a very similar case, also involving an arrest, also involving the allegedly drugs, also involving some physical difficulties with George Floyd. He had high blood pressure at the time and some other things you're going to hear about. So what the defense attorney, Eric Nelson, is trying to do is he wants to be able to talk about the 2019 case to reference the 2020 case. And he's basically making the case that it is so similar that we can show that there was a modus operandi here, that there was acting in conformity with prior experience. Every time the argument goes, every time George Floyd sees a police officer, well, he freaks out, has a panic attack, says some of the same things, calls out for his mother, calls out that he can't breathe, and so on and so forth. So so they're trying to show a couple things, that George Floyd may not have had difficulty breathing, that this was something that he just says, and we can point to the 2019 case to show that. George Floyd allegedly also ingested drugs at the last minute, which is in conformity with what happened in 2019. And so they're trying to get this in. You can see how powerful this would be if you could go in front of the jury and say, yeah, no, George Floyd in 2019, the last time that the police knocked on his window, he just ingested everything in his mouth. And that almost killed him back then. It didn't. He got medical treatment and he survived that. But he did the same thing again in 2020. And therefore, we're going to make the argument, or we want to show you the 2019 case to make the argument that supports that that's what happened again in 2020. So you can see that would be very, very provocative, I think. I think a lot of people on the jury would go, oh, wait a minute, that's what he does? Anytime the police come up, he just ingests whatever drugs he has on him. Well, that would lead you to believe that maybe it wasn't a knee on the neck that was the ultimate cause of death. It was, in fact, the drugs finally being processed by the body. And if he consumed them right about the time that the officer was knocking on the door, and he was basically dead 9, 10, 11 minutes later, you could process that maybe or make the argument, whether an expert witness will come in and testify to this, I don't know, but make the argument that what ultimately caused the death was the body processing the drugs that gave him the cardiac arrest that resulted in his death. So that's what we're talking about here. Whether the 2019 case can come into play. Judge, quite frankly, doesn't seem to buy it, doesn't seem to think that it's relevant, and he's going to explain some of that right here. So hopefully I framed that out enough. Here is Judge Peter Cahill giving us some background on the prior bad acts for George Floyd. Here it is.
Provided more information to the court. I'd just like to review where we are at. Originally, the state had filed a notice of intent to introduce this as additional evidence. And specifically, and this is going back to August 28th motion, that Mr. Floyd was engaged in the sale and possession of large quantities of controlled substances. When approached by police, he placed drugs in his mouth. In an attempt to avoid arrest and swallowed them, and when interacting with police, he engaged in diversionary behavior such as crying and acted irrationally. Point number 2, that when he was under arrest, he was cheerful because of being accused of selling drugs and for abusing opiates. And then number 3 is unrelated. That's not the May 6th. At the time of our motion hearing in September, court reviewed some body-worn cameras from the officers at the scene right up until the police station. And at that time, I granted the state's motion to essentially suppress this evidence because even if it's a modus operandi, that is how George Floyd acted when he was confronted by the police, it really isn't relevant. These are different police officers, and the police who deal with him, whether on May 6, 2019 or May 25th, 2020, have to deal with him as he presents himself. So whether it's part of a common scheme or plan or modus operandi or state of mind, it really doesn't matter. The intent that is relevant here is Mr. Chauvin, and he essentially has to deal with Mr. Floyd as is, without regard to, is it a common scheme or plan? Is it feigned, or, as Dr. Vinson would probably opine, it's anxiety or something else, a panic attack, genuine statements of claustrophobia. Whether it's any of those really doesn't matter, because the officers on scene have to deal with it as it is. So that was the original ruling and suppression of that. Since then, the parties have provided the court as a further offer proof evidence from a search of the squad car, Squad 320, which was the squad car that Mr. Floyd was placed in, or attempted to be placed in, on the date of his death, which was not searched until January of 2021. And am I correct that was the first search?
No, Your Honor, that was the second search. And the second search occurred only after the defense inspected Squad 320.
It's just kind of mind-boggling that an extensive search was not done until January 2021. Was the first one mostly just taking photographs?
Your Honor, the first search that was conducted, I believe, on May 26th or 27th, immediately following, the Squad 320 was searched. Numerous items of evidence were taken from that, including a ton of photographs. It was the defense review of those photographs that raised the question of what is all of this other stuff, why wasn't it taken? That's why we went to go look at it. But they did take DNA swabs. They took quite a bit of evidence from Squad 320 back in May of last year.
All right, thank you. Well, that puts it in perspective. But also, the body-worn cameras seem to include, I think, what is labeled as a narcotics body-worn camera. I'm not sure what officer it is. It's rather lengthy. It involves a lot of time where Mr. Floyd is in a conference room by himself, but also has a video of a paramedic dealing with him and checking his blood pressure. That was not part, or did I just miss it? Was that part of the September 11th motion hearing, or has that been supplied since then?
Your Honor, that was again when the parties were all joined, and the two of the other defendants made this motion, and Mr. Chauvin joined in that motion, and in the exhibits. I don't have a recollection as to whether that was included or not. I do know that it was specifically referenced in Mr. Tao's motion, and I believe that it was previously submitted as well.
Okay, and I think the motion was basically to talk about Mr. Floyd's manner and appearance during the arrest. And so the court made the ruling on that basis. Now we are at a different stage. Mr. Nelson, I'm going to ask you to approach the lectern and tell me why I should admit it and on what basis.
All right, so let's break that down before we talk about the defense attorney. So he's sort of framing out the court's original ruling, why they denied that. So again, the defense attorney's trying to get in that evidence of 2019 arrest of George Floyd. The judge is saying, well, it wasn't relevant. So we're not, I previously said that this is not coming in. We don't need to talk about it because it doesn't matter. It doesn't matter what happened in 2019. It only matters what happened in 2020 because Chauvin, Tao, any of the other officers who were there, they didn't know about what happened in 2019. So it wouldn't impact how they were dealing with him. They had to deal with him as he was right then and there. And so for the defense to come in and now say, well, yeah, but he was sort of acting in conformity with something that happened in 2019. He was following the same pattern. He says, well, so what? They still had to deal with him right then and there. If he had done that, if he had ultimately ingested a bunch of drugs, that doesn't impact Derek Chauvin's response and how he was supposed to deal with it. And so he's sort of, in my opinion, I think he's kind of making this more about the defendants and about whether Derek Chauvin intended to do what he did to kill George Floyd rather than identifying a different cause. So we're trying to sort of pin the tail on the donkey. Who is responsible for establishing this causal connection? What the defense is trying to do is say, well, this connection exists from this 2019 case because he ingested a bunch of drugs there. They're going to try to make that same argument. And that was the cause of the death. It was the ingestion of the drugs, not anything that Derek Chauvin had to do. It had nothing to do with the knee is going to be their argument. And the judge is saying, well, I'm not so sure about that. Derek Chauvin had to deal with him regardless of that, whether he was on drugs or not. It's kind of his responsibility either way to conduct himself according to the law. And the real crux of the case is whether that conduct was a violation of the law. So the judge, he hasn't issued a ruling on this yet. He's going to probably address it tomorrow, but this is a big, big part of the case. And so I know when you listen to some of this back and forth, it's kind of fast and they're sort of leaving out some of the colorful stuff to put some meat on the bones. But this is very important. If this comes in, it's a game changer. Probably is not going to come in because it would be such a big game changer. And again, they're going to weigh the sort of the probative value versus the prejudicial effect, whether or not, if this comes in, if this evidence of this 2019 arrest comes in, is that going to take over the trial? Is that going to overweigh any of the allegations that we're discussing right now? Is it going to confuse the jury or prejudice the government? Judge is probably going to find that, yes, it does. Let's listen, though, to Eric Nelson and see what he has to say.
Thank you, Your Honor. We are advancing 4 bases. First, common plan or scheme, otherwise known as modus operandi, habit, intent, and absence of mistake. I think what the court is alluding to is in terms of the conversation with paramedics, at that particular point, when the paramedics were checking Mr. Floyd's blood pressure, they specifically told him that his blood pressure was so high that he was in danger of having a stroke or heart attack at that point. And obviously, in this particular case, one of the primary cause of death is obviously cardiopulmonary arrest. So just to kind of work backwards, Your Honor, and I think that that's what the court was ultimately alluding to. The entire arrest in May of 2019, just over a year prior to Mr. Floyd's death, is remarkably similar in multiple ways from one to the next, from the May 6th of 2019 to the May 25th of 2020 arrests. Beginning with literally the initial approach of officers and how the officers reacted to Mr. Floyd in that circumstance. In both of these cases, Mr. Floyd is in a vehicle, and one it's a traffic stop, and the other he's already parked. Officers approach, and the officers notice that Mr. Floyd begins acting furtively, hiding his hands. He's refusing to show his hands. Both officers in both incidents draw their weapons and escalate the use of authority or force in that regard. Mr. Floyd struggles. They struggle to get Mr. Floyd out of the car. Mr. Floyd immediately claims that he has previously been shot in both incidents. Mr. Floyd, again, struggles to get out of the car. He appears to resist their efforts to handcuff him. And he starts saying some of the exact same things that he says in this particular case, in the May 25th of 2020 incident, including calling out for his mama. He claims to have been shot, and he begins this crying, kind of erratic behavior. All of Mr. Floyd's behaviors at that point are identical. Now, in the May 6th of 2019 incident, officers actually observe Mr. Floyd begin to put what they suspect are controlled substances in his mouth. And they threaten to tase him. They say, spit it out repeatedly. Mr. Floyd refuses to comply. And he obviously takes these controlled substances. A search of the vehicle in the May 6th of 2019 incident reveals a large quantity of a variety of controlled substances. At the time of the original motion in this case, we had taken screenshots from the arrest in May of 2020 showing what we believed to be controlled substances in the mouth of Mr. Floyd at that time.
Well, in fact, I think I stated that in one of our hearings,
You
whether
did.
it was June or September, and the court, or the state at that time, before item 51 was found in the squad, I believe correctly and said, we don't know that to be the case, that is a pill or spit or something else.
That's precisely it, Your Honor, and that was that. They said, we don't know. That could have been, could have been gum. It could have been something else. We didn't know with definite positivity. I don't think anybody could say with definite positivity at that point that that's what was in his mouth back at that motion here. Now, there are so many other similarities between these two incidents, including officers believing that Mr. Floyd was under the influence in both cases. In the May of 2020 incident, officers King and Lane are asking him immediately upon taking him out of the car, what are you on? What are you taking? They suspect that he is under the influence of something. They don't know what. What are you taking? They notice a white foam around his mouth or a white residue or something around his mouth. That same observation is also made by officers in the May 6th of 2019. So there are all of these remarkable similarities. The difference is, the primary difference is that in the May 6th of 2019 incident, when they put Mr. Floyd into the squad car, he never makes a claim of claustrophobia. He gets into the squad car and he continues kind of the crying and erratic behavior in the squad car. As his body ingests or processes the controlled substances he took, you can see his demeanor change in the cameras, where he goes to an almost incoherent state while he is in the police station in the May of 2019 state, resulting in the police calling paramedics to the scene, and ultimately the hospitalization of Mr. Floyd. And there are the associated medical records from HCMC, or what was then known as HCMC, about Mr. Floyd's hospitalization. Those records indicate that on that particular day he took 7 or 8 pills prior to being arrested by the police. The paramedics in that instance, right, when they originally respond to the precinct in May of 2019, they specifically tell him, they're monitoring his vitals, and they tell him, you're at risk of having a heart attack or stroke. And his medical records also clearly demonstrate that he has a history of high blood pressure and hypertension. He had been prescribed medications for those. So you've got a person who is being specifically told this behavior, or presumably this behavior, is putting you at risk of having a heart attack or a stroke. So when we look at the exceptions to the general 404B exclusion, we look at common plan or scheme, right? Is this something that is so similar? Is this just that this is his modus operandi of when he gets arrested by the police? In particular, when he's in possession of controlled substances. So you look at this, and the similarities are incredible. I mean, it's the exact same behavior in 2 incidents, almost exactly 1 year apart. You also look.
All right, so we'll stop it right there. Yeah, very, very, very interesting there. Let me try to break it down just a little bit. I think he did a very nice job explaining about what he's trying to do. He's going back to the 2019 case. He's comparing it to the 2020 case, and he's saying, look, there are so many similarities here that we can presume safely that he probably was acting in conformity with the same behavior that we saw in 2019. And so let's think about this from a policy level. Why does the court not want that to come in? Why do they not want to hear about this at all? Because you may be watching this going, well, yeah, that's absolutely relevant. Are you kidding me? If he was arrested in 2019, ingested what he said, 7, 8, 9, 10, 11 different pills, was hospitalized as a result of it, and was told that that he had other heart problems back then. We know from the current autopsy report that he already had heart problems, 2 different types that we covered, also had COVID and some additional things in there. But if you can show that in 2019, that's what he did, and Eric Nelson goes through it, and it says when he's in the back of the police car, and they had already told him to spit out the drugs, he consumed them. And then as his body is processing the drugs, he goes from his very excited, almost delirium state into somebody who is overdosing on drugs right in front of their eyes. Sort of as minute by minute it goes by, you can see his demeanor change in the back of the vehicle. That happened in 2019. And it kind of sounds like exactly what happened in 2020 is the defense argument. And he's saying, we want to be able to talk about that. And you say it might be obvious, right? But why would the court not want that to come in? Well, it's because if it does come in, you can feel kind of how damning that is. You can just feel that a juror, you might be sitting there watching this going, oh yeah, that changes the game. That changes everything. If we know that he did it before, we can presume he did it right now. And so that might be the whole trial, just based on that fact. And so the court doesn't want to do that. They don't want a trial based on some prior incident. They want it on these facts right here and now. And so they don't want to give either the prosecution or the defense. And remember, typically this is the government trying to get this evidence in. Typically it's George Floyd or somebody in his position would be the defendant in the case. And the prosecution wants to come in and bring in all of the priors and say, look, this guy stole a candy bar in 2018, 19, and 20, and so now it's 2021, and we think he stole a candy bar, but we don't really know. So we don't really have any evidence in this 2021 case, but we do have evidence about 18, 19, and 20, and so we're going to try to bring in all of those prior bad acts of the candy bar thefts from those prior years in order to prove the 2021 theft. And of course, that's not right? You can't do that because you can't presume that. And there's a very, very big risk there that maybe that time in 2021, he didn't actually steal the candy bar, but he's getting pinned with this one because of his prior bad acts. And so the courts get very concerned about this. They don't want to allow this stuff to happen. They know that it's bad. They know that it's dangerous. They know that if a jury heard this, it might be the case right there for him. And so the judge is really going to do what he can to keep this stuff out because it is so impactful. And so what Eric Nelson is doing is he's trying to argue some of the exceptions to the rule. And he goes through and he talks about habit and modus operandi. And there's some different exclusions that say, well, we know it's so dangerous that we really are by default not allowed to talk about this stuff. But in this limited case, because it is so important as to one specific issue, they ask the court to let it in. And so the judge is going to have to make a big decision on this. And it's going to be contentious. I'd say this is probably the first major contentious decision that we're going to get from the judge, whether to allow this or not. The other issues are important. Some of the jury questions I think have been pretty fair. Some of the motions in limine rulings have been fair. We have sort of fair guidelines across the board for expert witnesses and non-expert witnesses. And the judge, he's given us some guidance a little bit on whether he's going to sequester the jury or move the trial or continue the trial. And those are all sort of procedural issues. The settlement is a big issue, but that's not really within his wheelhouse. He's sort of having to deal with the damage and the spillage that's happening from the city council's incompetence. But now that he's going to work through those issues, this is the big decision for him. Does the prior come in or not? The government, of course, does not want it to come in. Typically, they want this stuff to come in because it makes the defendant look bad. But here, the tables are turned a little bit, so they really do not want it in. So this is, again, from the Star Tribune. It says, Judge Cahill questioned why the 2019 arrest is relevant, saying these are different police officers. Police have to deal with Floyd as he presents himself. Nelson countered, Floyd's behavior in the two incidents establishes a pattern. There are other similarities between these two incidents, including officers believing Floyd is on drugs. The similarities are incredible. It's the exact same behavior in two incidents, almost exactly 1 year apart. Prosecutor Matthew Frank came in here, and he called Nelson's motion to admit the 2019 arrest, quote, a desperation of the defense to disparage Floyd's struggles with opiate addiction. Frank accused the defense of trying to, quote, smear his reputation because he acted this way once before. Cahill said the May 2019 hypertensive incident goes to a possible cause of death in May 2020. In both incidents, Floyd had ingested drugs. That's the only relevance I see, adding that he would rule later on the issue. So again, this judge is going to have to give this some serious thought about whether to allow this in or not. I do not think that he allows it in. I just don't think he does because of its impact. Now, should he? That's a different question. We're going to have to see how these arguments flesh out. We're probably going to hear more arguments about this tomorrow. So we're going to switch gears a little bit. Of course, we're going to stay up to speed on this, but that's all taking place tomorrow. All right, so now let's talk about the jurors. So it looks like my emojis weren't fixed for some reason. One of them was fixed, so this one's good. But the old white woman is not showing up. This should be an old white woman with white hair. But that's our jury. This is what it looks like with demographics included with the emojis. So we've got 9 seated out of 14. No new additions to the jury panel right here. Mr. Blackwell, we saw yesterday. Sandeep. We saw the prosecutor, who is the assistant attorney general. He was doing a lot of the arguing today, a lot of the voir dire. And so, of course, the defense team has not changed either. We have no new jurors on the panel. Let's talk about the people who were booted out of here. We've got the first one. One jury candidate expressed concern that being a juror for several weeks during the school year would make it difficult for her to maintain in-class responsibilities as a teacher. The next prospective juror revealed that a work project he is on routinely exposes him to news headlines, including the one last week about the settlement, right? Everybody's going to see it. So 2 people were stricken there. We got 1 and 2 out. We've got then a woman was dismissed after explaining She's scheduled to move into a new home during the trial and has a child under 1 year old. All right, so she's out because we can't get her under sequestration. Cahill noted that 8 of the previous 11 possible jurors have been dismissed for various reasons rather than being seated or struck by the defense or the prosecution. So 8 out of 11 are they're just not. They just can't do it because the news and the media is so everywhere that they just can't escape it. They have also got some scheduling problems and things like that. I think some of the scheduling problems are, I don't know. I can't speculate, but you would think that a lot of that would have been figured out kind of before they get into the seat, but the judge is moving them on quickly as is. We've got some other people who got booted out. Extensive questioning by the defense of a 4th jury candidate on Tuesday yielded the same result, despite the man saying without qualification that he could judge the case fairly. Still, the defense used one of its peremptory strikes to dismiss the executive director of a youth organization who has the most interaction with police among potential jurors questioned so far, which is interesting. If he works a lot with the police, why would the defense strike him? Maybe he has some sympathies with the police that would make him a good juror. He said that in his childhood, he and his sister had to call the police when their parents would argue and physically fight. He added that he had no issue with how the officers responded in each instance. He also shared that he's a skateboarder. At times, you get yelled at by the police for cruising down the street. He called one time in Georgia when, as a youngster, when he and others were allowed in a skate park in the middle of the night. Police arrived, thought there was a break-in, and were pretty forceful verbally until the officers learned that the owner left a key for them. So he struck him. We don't see anything in this article about specifically, anything that I would see that would cause attention to that, but maybe it was just some of his appearance or how he was communicating his perspectives on the police. The defense also used the strike to excuse the morning's final jury candidate, a lover of the outdoors and fishermen, which you would think demographically tend to be more conservative people like police more than non-conservative people traditionally. These are broad strokes, but this is how it works. He said he could judge the evidence fairly and give Chauvin his constitutional right to a presumption of innocence, even though he thinks the defendant murdered Floyd. So there you go. That's why he got stricken with the peremptory. Said, I think it's very difficult based on what I've seen and what I've heard, but it's something I would definitely do, referring to his presumption of innocence. So he also got the strike. We have another one. The day's final jury candidate was questioned extensively about a long and close friendship with a police officer who works for large Twin Cities agencies, which is not the Minneapolis police. The man, a real estate agent, said he's gone on a couple of patrol ride-alongs. I did one of those in law school with his friend and saw, among other things, a citizen suffer a serious head injury, a drunken driving traffic stop, and someone who had died. All right, so this guy seems like he's got a lot of connection with law enforcement. So what is the prosecutor going to do? Let's take a look. Prosecutor Steve Schleicher posed many questions about the man's ability to weigh testimony from a law enforcement officer versus that of a bystander in light of the friendship and the ride-alongs. He said, quote, naturally, I would believe the police officer more, said the man, who lives in a suburb and has 3 grown children because they have more experience and training with what's going on than someone who is walking down the street. Cahill stepped in and zeroed in, so Cahill's the judge, and asked whether the law enforcement officer is more likely to tell the truth or a citizen. And he said, I guess more likely the police officer. The judge then excused the prospective juror, sparing the prosecution from using one of its remaining strikes. And, I didn't see this exchange, but that's very nice of the judge to do that and go in and strike that person for cause. I think that, if the guy said that he wanted to be fair and impartial, like some of the other people who've made it onto the panel, then maybe that could be salvaged. But again, I didn't watch it. So he got stricken by the court, stricken for cause. Probably the right thing, right? The guy said pretty clearly that he thinks that police officers are more likely to tell the truth. If you have 2 competing versions of events, then he's going to side with the police officer in front of a regular civilian. And this is so interesting to watch because typically we have to make those arguments. We have to go and convince people or communicate to people that, hey, just because he's a cop doesn't mean that everything he says is true. Just because he's wearing a uniform and a badge doesn't mean that he's as honest as, Mother Teresa or something. That's not the reality at all. Typically, we're trying to sort of explain to jurors that you don't have to believe the police. If he says the light was red and somebody else said the light was green, those are both equal. Those are both credible statements. And just because one is an officer doesn't mean that they've got more credibility than somebody else. Yes, they have more training, but it doesn't make their observation any less credible. just because of that, or any more credible because of that. And we have to sort of really flesh that out for people. Now it's the prosecutor who's having to sort of reverse that. The prosecutor is typically on the side of the police. Now he's having to go in there and find people who are a little bit questioning the police, whereas the defense is trying to find people who do in fact believe the police. And so it's sort of a reversal of the roles, which is always fun stuff. All right, so this is what the jury looks like. We've got, again, this is an old white woman, apparently not old. She's in her 50s. I shouldn't say that, right? But she's in her 50s. But it looks like this emoji. Okay, that's the emoji that I selected. So the emoji thing is turning into this whole racial just debacle. I'm not sure what kind of can of worms I've opened here, but that's how this stuff works. So we've got potential to, theoretically finish jury selection this week. Maybe we get 2 tomorrow. We've only ever seen a maximum of 2 added. So it would be 2 tomorrow, 2 on Thursday, and maybe 1 on Friday, or some combination thereof. So I think it still is possible to finish out the day, to finish out jury selection this week. Probably not going to happen though. We'll see. We've got a lot of other issues. This is the demographics board. So we can see no changes there from yesterday. So don't want to spend too much time on that, but just wanted to show that up for you. So let's take a look at some of the questions over from News Now Wyoming. These questions are being asked on watchingthewatchers.locals.com. You can support the show over there and ask some questions as well. So head on over there. First one comes in from News Now Wyoming. Do you have an opinion on how much of the prior act of George Floyd should come in? Watching the arguments this morning and hearing the judge's response, I can now understand why it may come in. Part 2 of my question, the judge said he can let in some, not all. So the medical expert saying, quote, this is the way George's body reacted to an overdose before, but leaving out anything about the arrest. So, it's a great question, News Now Wyoming, and I do have opinions on it, but I'm not going to share those right now. Number one, because I don't have all of the information out thus far. I would like to hear more about I'd like to see more of the evidence and specifically what they're talking about. The things that we have seen thus far are just sort of very surface level arguments. I personally think that it is relevant. And when we're having this conversation, we have to ask the question, why do we want that in? For what purpose? And you have to be very clear and articulate what purpose that is for. Is it to show that George Floyd took drugs? Well, we don't really know that, right? I mean, there's indications of it. We heard about the screenshot. It could have been gum in his mouth. It could have been spit. It could have been pills. It could have been drugs. We don't know. So is it to prove that, or is it to prove, or to at least cast doubt upon the ultimate cause of the death, which I think is really what it's intending to show. And so, I don't really have an opinion that I'm prepared to share right now. I certainly will critique the opinion that comes out. Part of the problem I have with sort of armchair quarterbacking this thing is that I haven't seen almost any of it. I've basically seen what you've seen. And so it's hard for me to give a very clear opinion on it. If the judge lets it in, I think that would be more appropriate to give context to this entire situation. But I understand if the judge doesn't. And if the judge splits it down the middle, that'll probably be fair. It's a good question, though. Sorry, I don't have a better answer there for you at News Now. It's a complicated issue, and so I kind of don't want to be too political with this issue, with this entire trial. I kind of want to just be more of an observer rather than somebody who's being a little bit more prescriptive about what I think should happen or take a side one way or the other. My big take here on this George Floyd stuff is I want a fair trial for both sides. Okay, I'm really not trying to get overly invested in one side or the other. I want to make sure that we're monitoring it and talking about it from the concept of fairness, impartiality, with due process, without any undue influence. And I'll be happy as long as we get something that looks close to that, because this whole thing is so messy that it can spiral out of control in a number of different ways. And I feel like the people who are politicizing this on both sides are doing a disservice to the justice system. And they're free to do that, right? They can have their opinions on it. But if somebody comes out and says, well, George Floyd was was murdered and Derek Chauvin was acquitted because of, white racism or the white patriarchy or something like that. Right? I want to be able to say, no, look, we covered it. We talked about it for almost an hour every single day of trial. We analyzed it, didn't see any of that stuff. And I want to be able to have some credibility when I make that claim. Or conversely, if everybody comes out and says, hey, Chauvin was convicted in the most unfair, most biased, most out of control kangaroo trial that we've ever seen, I want to be able to share my perspective on that without being too lumped in with one side or the other politically. And because truthfully, that's really what I believe in. That's kind of where that's my practice, the law firm here, right? We think that our clients deserve a fair trial. Doesn't even matter what they did. They deserve due process. They deserve their day in court. They deserve competent representation. And so Derek Chauvin deserves that as well. George Floyd and his family deserve justice also. So that's where my interest is, rather than making this overly political or trying to predict or sort of communicate where I think this is going or should go. We just want to analyze it. So, and I know that was a long little tangent, but thank you for indulging me. Ma Fox says, would the civil case be available for legal professionals via PACER with the estate of Floyd versus state case? We could figure out if the statement is accurate if transcripts, opinions are in writing. Yeah, good question. So, I don't know. I don't practice much, zero civil law, actually. So I don't know if those settlement agreements are on PACER, but I do have access to PACER, of course, so I will take a look and see if it is on there. Some of these settlement agreements oftentimes are just confidential, right? So they sort of will file a notice of settlement, but not the details of the contract. So they'll notify the court that there's a settlement that's been reached. It's kept under seal. It's all private between the parties. They're just notifying the court so that the court can then be aware and then be prepared for a dismissal of the litigation and take it off the docket. But that may be all that we see. But I will take a look at it. It's a good question. We should look at that. Ma Fox says, any sort of informal or formal opinion from the judge to two opposing counsels seeking RFCs would be on the record, correct? So what's an RFC, Ma? Throw that in the chat. I'm not sure what you're referencing there. We have, are they arguing whether to allow certain evidence? So yeah, so Ma, tell me what you're referencing from an RFC. And then I'll answer that. Jeremy Matrita says, are they arguing whether to allow certain evidence? Yeah, they are. And specifically, it is the 2019 Prior Bad Act. And that is George Floyd's prior arrest. They're also having conversations about Derek Chauvin and his prior disciplinary records. But the judge at this point in time has said those are not coming in. And Floyd's 2019 prior are not coming in. All right. So Ma says it's a request for comment. So any sort of formal or informal or formal opinion from the judge to two opposing counsel seeking requests for comment would be on the record, correct? I don't even know what you're referencing. So a request for comment on a motion or a settlement. I'm sorry, I'm totally blanking. I apologize. It's not you. I'm sure it's me. We have Nadar Lasir says, I'm not the brightest knife in the fridge, but even I know that releasing the settlement is irresponsible because it could potentially interfere with the idea of a free trial. If I know this, I'm willing to bet that a government official does too. So I don't believe their reason to do that was anything but maliciousness. Yeah, and it really does feel like that. I mean, they could have settled this before. They could have settled this after. They could have done like they have done historically. There's precedent for this, that in Minnesota, when they settled the Noor case, we heard about this yesterday, they announced the civil settlement the day of the verdict in parallel with the criminal case, resolved the civil case and the criminal case in parallel. City Council did that like a year ago. So they know that that is an option. I'm going to guess that a lot of the same people who are on the City Council for the Noor case are also on this on the City Council for the current case. And for them to just go, oh, we didn't know. I mean, yes, golly, we're just trying to do our job as good city council people just to sort of rectify the situation with the Floyd family. We didn't know any better. Yeah, right. You all did. You knew what you were doing. And you did it intentionally at a time when it's very, very damaging to the case. Certain things happen when a jury selection starts. You kind of got to keep going once you start to impanel the jury. You can't really stop. If they would have done this, let's say, a week before jury selection started, the defense attorney could come in and say, well, we need a continuance on this. We need to change a venue. The court would have had more remedial options in order to address the potential for bias there. But now they just don't. They got to just, all right, well, we have like 7 jurors seated. We don't know if they're tainted. Now we have a bunch of other new people who are coming in. We got to ask them now, not only did they see the video, but did they also see the settlement? Because the city council just keeps dumping their garbage onto us. So the court is rightfully frustrated. I'm frustrated. It's like, what are they doing? It is not conducive to a fair and impartial trial. And the prosecuting attorney yesterday said something like, well, I don't know which way it cuts. Yeah, we all know which way it cuts. It's not good for the defendant. All right, next question. Here is Ryan. Says, how can a judge reasonably exclude evidence in a murder trial, in this case, ingestion of dangerous drugs, which can be medically contributing factors to the death, especially when ingestion immediately prior to the police confrontation would potentially point to a motive of framing the defendant via self-harm and suicide? Yeah, it's a good question, Ryan. A very, very, very astute comment here. And I think really what they're pointing out, or what the judge is trying to go to, is he's not necessarily talking about, well, so it depends on what we're talking about. If you're talking about the 2019 case, well, yeah, you can make an argument that that's not relevant. Okay, whether he ingested drugs in 2019 has no bearing on whether he ingested drugs on this day. If the defense thinks that happened, then they can present their evidence about what happened on this day. And the judge might go that route, right? He might just say, no, they got to prove it. If there was an ingestion of drugs, they can use the photograph. I think we've all seen the photograph where George Floyd is sort of sitting in his car with a shocked face, and you can see into his mouth, and he has something on his tongue. It's a pill, or it's a gum, or it's just, spittle that has accumulated there. We don't know. So the defense can make that argument. Now they want to be able to make that argument and reference the 2019 case and say, look, it happened back then, so this is what we think happened now. That's the crux of the argument. That's what they're trying to convince the judge of. And the judge might say, well, you can't do that because it's too damaging. It's too prejudicial. It's going to confuse the issues. It's going to make this trial about a 2019 case, which this is not about that. It's about a 2020 case. And so that's the argument. And so I think what we could be talking about 2 different cases and sort of confuse the issues. You got to make sure that we're keeping them very separate. If they're allowed to talk about 2019, it's for what purpose? And so they're going to have to flesh that out. But very, very great question, Ryan, and you've got a good handle on sort of the progression on how this is working. Paula MK says, if Chauvin is convicted, would the settlement be announced during voir dire be sole grounds for appeal? From a non-lawyer but true crime junkie, it seems that in order to get appeals heard and verdicts overturned nowadays, it takes a momentous act of God. Yeah, appeals are difficult to win. I mean, basically, you have to show some sort of abuse of discretion or some sort of issue that would have been fatal to the underlying case. It's a higher standard. Many people think that you can just lose a trial and just appeal for whatever reason. Well, I don't like the verdict. I don't like the outcome. No, that's not it. You have to show that procedurally that there was something that went wrong. Some evidence came into court that shouldn't have come into court. The judge made a decision about something that shouldn't have gone that way. I don't think that the fact that there was a settlement by itself is enough to say that this should be overturned on appeal, because it's definitely impactful. It's definitely, biased and prejudicial, but it is something that is external from the court. It's outside of the court. So the defendant, Derek Chauvin, would need to show the Court of Appeals or a higher court that something happened in the trial that was problematic. And one of those things could be that the judge dealt with the settlement inappropriately. The judge didn't grant a continuance, or didn't change venue, or didn't give him more peremptory strikes, or didn't strike certain jurors for cause after they've acknowledged that they've heard about the settlement agreement, or didn't sequester the jury. Any of those things would be appealable issues, which is why we're hearing Eric Nelson go down the list and just stake those all into the ground and see if something happens, if Derek Chauvin is convicted on the basis of one of those erroneous decisions, then that would be appealable. And then if that would potentially change the outcome of the trial, or the court could remand it for a new trial, there's a lot of different ways this can go. And it's too early to tell and dial in on the specifics. All right, Ma Fox in the house says, I'd like to know how long it took before the drugs took effect in his system in the 2019 case. I feel that'd be relevant. Effect in less than 15 minutes from a pill form is highly suspect in my opinion. Yeah, it's a good question, Ma. And I think there was some indication, not from the clip that we heard today, but from a clip that we played previously. It may have been last week, also from Eric Nelson, also talking about this issue. And he said that there was something in one of the reports somewhere where it sounded like George Floyd was actually chewing the drugs and just so that he could digest them very quickly. So because if I'm remembering correctly, there was some indication that from the report that there was saliva and residue from chewed up drugs. So sort of the pill form crushed up as he's fighting with the cops. It's sort of coming out of his mouth and it's smeared around the back of the police car. That's what they found. So if he is chewing it up and it's going directly into his bloodstream through his mouth, that might affect the timing. I don't know if it makes it, I think it makes it significantly shorter because it's going directly into your blood, not going through your digestive tract. But you'd also have to sync that up with the timing in the case. When did he start to, become under the influence of the drugs? We have Ma Fox says, any sort of informal or formal opinion from the judge to two opposing counsel seeking RFCs would be on the record from the judge on a settlement issue. Okay, so I think we're talking about, so a settlement issue. So the closest thing that I can analogize to here, Ma, is a settlement conference that takes place in a criminal case, okay? Because I don't do civil law, so I don't know what an RFC is, if that's a real thing, or if that's a thing in civil law. I'm sure it's a real thing, but I'm not familiar with it. So when we have settlement conferences in criminal law, those are informal proceedings. They're technically recorded, but they're also off the record. And so they're sort of in this little bit of a gray zone where you can say what you want on the record. You can be open and exchange information, exchange ideas. Well, what happens if we do this? Then the prosecutor can tell us that. What happens if I take this plea? We can explain what the penalties would be. What happens if I go to trial? We can talk about what the penalties might be. And so you can just kind of hash out a lot of issues back and forth in the conversation of settlement. And the benefit of that is you want both parties to be able to come out there and just communicate openly, candidly. You don't want people to be hiding behind fear that if you say something that's stupid or you incriminate yourself, that is going to be used against you. So you could say to the prosecutor, if I did that thing, or if I gave you information about this other thing, might we be able to negotiate it, and it might incriminate that person, but it's all sort of off the record. It's all informal, so you can have legitimate conversations. And a lot of those are just not available. Those are protected. Those are confidential. People don't want you to see that because it is sort of a sacred communication, free, off the record conversation. And so I'm going to guess that there's a similar version of that for George Floyd and his settlement with the family, that there are conversations that are public and that the judge will happily keep a part of the record. And then there are other areas of settlement negotiations that are just not on the record. Those are secret and you wouldn't be able to get access to any of that stuff. I would think that that would be similar, but I am actually going to look up that case on Pacer as soon as we're done here on the show, matter of fact. And I'll see you on Clubhouse, so we'll dive into that one as well. Paula MK says, also, do you know if the medics that were on the scene during Floyd's arrest are going to be witnesses? Almost certainly. I don't know for a fact, though. When the video first came out, I and my other shift medics didn't understand why the medics on scene weren't following normal protocol for cardiac arrest. Yeah, good question there, Paula. Very good question. I would be curious as to what your speculation on that might be, whether you think it was because they did something negligent there, or because they didn't identify this as a cardiac arrest, or what. I don't know. But yeah, almost certainly they're going to be there. I think most of the witnesses who were there, the people who recorded the videos, there are hundreds of witnesses on the list. We just don't know who's ultimately going to get called. Liberty or Death says, I was watching and saw the judge strike the last guy. His answers were subtle but slanted. I thought the judge was nice in excusing him, but for the same reason he did not grant Nelson's motion for another preemptive challenge, he should have left it for the prosecutor to use one of his strikes. Yeah, so you did watch that. Yeah, so I didn't watch that part of it live. I just was sort of clipping from the article. But yeah, the defense, did they get that same courtesy from the judge? The judge kind of stepping in and excusing people so that they don't have to use their peremptories. Now, the defense has more peremptories in the prosecution, but still, if you're going to be striking people who are kind of slanted for cause for the prosecution, you got to do that for the defense. And I didn't watch that one, so I didn't want to beat up on the judge too much a little bit, but it sounds like liberty or death. You were picking up what I'm putting down. We got Jack Elia says, wouldn't the city lose the civil suit since their training standard instructed the hold pin used by the officers and neglected to instruct them not to affect the hold pin for X minutes, nor any other restriction of its use? Wouldn't the city lose the civil suit since they instructed and neglected to instruct them not to affect that hold for X minutes, nor any other restriction of its use? So good question, Jack Elia. I would say that is for a civil lawyer and the civil different standards. It's irrelevant right now because there is not going to be a civil lawsuit. They settled it. Maybe their attorney came to the same conclusion and said, no, we're not going to risk this at trial. If we take this case to trial, we could lose. The settlement could be for $127 million for all we know. So we're just going to settle it for a steal at a cool $27 million. And that's that. They're not going to have to move forward. They may have made that calculation, or maybe not. Maybe they just said, yeah, we could win at trial, but we're going to make a political decision here. We're going to say that this is in the interest of settling down the city, calming down the city, calming the nerves for whatever reason. Maybe they think Chauvin's going to get acquitted. Maybe they think he's going to be convicted and it's still the right thing to do. Who knows? But it'll be curious to see if as this continues on, new comments or new story or emails or something leaks about the deliberations that were taking place in order to effectuate this settlement agreement. So that is it for the Derek Chauvin trial. We're going to be back tomorrow. We're going to see if we get any new jurors. We're going to see if we have any answers on the 2019 prior, whether that's going to be admissible or not. And so we hope you join us, same place, same time, for that conversation.